Hi guys. I couldn't I was going to do another video yesterday to continue on with the definitions of the jury instructions. But I had a DKA, which is a diabetic ketoacidosis, which I overcorrected for and ended up in a hypo. So I just I didn't feel very good after all of that. I'm fine, but I didn't feel particularly great after all of that, and I just wrote off the day. Just had an early night. But we're gonna go through this now. So my video yesterday did the opening instructions to the jury and then the closing instructions to the jury. We got to see sort of proposed amendments by both sides, and that the reasons for what they were objecting to about the others, or the reasons why they were making a specific proposal. This looks more into the sort of definitions. Um, so here is retaliation instructions. Now, Lively is trying to push that Wayfarer and it ends with us movie are one and the same, but I don't think she's got a leg to stand on here, because the judge commented in his order on the motion for summary judgment that she had pretty much abandoned the alter ego theory herself that she was, trying to advance. And it just doesn't work like that, much as, you know, you can't just swap out an individual for a corporate entity when it comes to contracts. You can't swap out you can't kind of merge, in a sense, because Wayfarer had, for the purposes of the film, they had specifically created the Endless Movie LLC. And there are several reasons for doing that. That then runs separately. It might have some of the same staff from Wayfarer, you know, and the same management and leadership, but it is still a separate entity, in as much as Van Zan, is not the same as Blakel Inc. or Maximum Effort. They are separate. Legally, they are separate as well. They pay their own tax, they have their own bank accounts, etc., etc. They have their own set of rights and responsibilities and their own set of burdens. So you can't just, she's got this thing where she just likes to, oh, it's okay, well, it's basically the same thing. It is not. But either way, she is going to attempt it. And she is saying to the jury, single integrated enterprise. So she is proposing the instruction that Wayfarer Studios and It Ends With Us movie operated as a single integrated enterprise and are therefore both responsible for retaliating against her. In deciding whether, so what that means is, well, if one's responsible, then they both are, right? Which I don't agree with. Because if, let's just say she has, that the jury agree with her as to It Ends With Us movie, then no, it should not automatically follow that also applies to Wayfarer. It shouldn't. Plus, it's also a way that of doubling up potential damages, because if she is going to get damages from Wayfarer, and then also she would then be, by default, if this is successful, this proposal, she will be awarded damages automatically from Wayfarer as well. So, in deciding whether Wayfarer Studios and It Ends With Us movie operated as a single integrated enterprise, you should consider all the circumstances, including the following factors. 1. Interrelation of operations such as shared services, personnel, offices, or operational systems. 2. Common management, including overlapping officers, directors, or managers who made decisions for both entities. And I find this a bit rich from Lively, who owns several entities, but would not, you wouldn't have, I don't know, Blake Brown Beauty being held responsible for anything that Betty Buzz did. Centralized control of labor relations, including who made or controlled decisions about hiring, firing, discipline, workplace policies, or employment complaints, and common ownership of financial control. No single factor is required or decisive. However, the most important consideration is whether Wayfarer Studios exercise centralized control over employment decisions, particularly decisions involving hiring, firing, discipline, or other terms and conditions of employment in connection with the film. If you find that Wayfarer Studios exercise such control, you must find the entities operated as a single integrated enterprise and were both Miss Lively's employer under FIHA. Now, that's not going to wash because they weren't her employer. She was, she was, they may have been her contractor because she was self-employed. Judge Lyman did actually find that. I'll tell you, do you know what? I'm going to get on a soapbox a little bit here. Do you know what else bugs me about this FIHA claim being still in? Is that it is a California state law, right? And it really pisses me off because nothing happened in California that harmed Blake Lively. Even if she proved her claims, none of them took place in California. And for me, it's like saying, I'm going to claim against you for whiplash, but I wasn't in the car. Like, it doesn't make sense that she's able to bring this claim. Okay, so defendants don't have a proposed instruction, but let's look at the kind of, the rationale and the objections. So the plaintiff's position on this, Lively's position, plaintiff asserts that Wayfarer Studios and Ainsworth's Movie LLC are operated as a joint employer and or single enterprise such that Wayfarer Studios and Ainsworth's Movie LLC were both Miss Lively's employers and may both be held liable for retaliating against her. That Miss Lively has been deemed an independent contractor rather than employee does not negate these tests. And okay, we'll give her that. And defendants cite no case law to support such position. But let's have a look at what defendants say. What does Wayfarer say about this? Plaintiff's instruction mislabels and misrepresents the joint employer doctrine. Yeah, it does. It is incorrect for numerous reasons. First, a joint employer instruction has no basis here. The court has already determined that Miss Lively was not an employee. Thank you, exactly. And that neither Wayfarer Studios nor Ainsworth's Movie had sufficient control over Lively to be considered Lively's employer. Yes. Plaintiff's cited authority only relates to employees. So she would have had a point in a different situation, but to Lively's situation, it doesn't apply. She's already been deemed by the court to be an independent contractor. Neither of them were her employers. And, the actual joint employer doctrine, she's misapplying it here. Okay. Plaintiff cited authority only relates to employees. The instruction is also incorrect, also an incorrect statement of the law, even if Miss Lively was an employee. Second, replacing the term joint employer with single enterprise is confusing and inappropriate. Wayfarer and Ainsworth's Movie are legally distinct, which is exactly what I've just said. Right? They are their own legal entities, and you cannot just switch between them. Otherwise, people will never know who they're actually contracting with. Moreover, as the court observed in its summary judgment ruling at page 22, plaintiff has abandoned her alter ego arguments as to those entities. Exactly. Elements of retaliation, which pissed me off because in the verdict form, Lively left out all of that. Miss Lively claims that Wayfarer Studios, Ainsworth's Movie, retaliated against her, one, because she engaged in a protected activity, including by complaining about or opposing alleged harassment based on sex or gender. Or two, because Wayfarer Studios, Ainsworth's Movie anticipated that she might engage in further protected activity. To establish this claim, Miss Lively must prove each and all of the following. And it can't just be some, it's got to be all of them. Okay. 1. Miss Lively engaged in protected activity, including by complaining about or opposing a hostile work environment based on sex or gender. 2. That Wayfarer Studios, or It Ends With Us movie, subjected her to an adverse action. 3. That Miss Lively complaining about or opposing a hostile work environment was a substantial motivating reason for Wayfarer Studios' It Ends With Us movie conduct. 4. That Miss Lively was harmed. And 5. That Wayfarer Studios' It Ends With Us movie's conduct was a substantial factor in causing Miss Lively's harm. Even if she hit all of the other 4 points, because she did oppose certain behaviors that she believed were related to her sex. Right? So that she did. Wayfarer acknowledged that too. So did Jenny Slate. I think one of the key questions was going to be, okay, well, why would they smear Blake Lively but not Jenny Slate? Because Jenny Slate believed that, well, it was she was literally asked, why did you not take any further? Well, it was resolved to my satisfaction. It was resolved. That was the end of it, and she didn't believe it to be sexual harassment either. So there is that. And then we have point 2, which is she's got to prove that Wayfarer, It Ends With Us movie. I'm just going to say Wayfarer from now on, but we know that I'm talking about both. She's got to prove that Wayfarer basically subjected her to an adverse action. So that is, they retaliated against her. They did this digital campaign, smear campaign that was untraceable. Now let's look at that, because we actually did get a little bit of a flavour of what exactly is Lively saying, they said. Because she's already had to concede that Shusty's video had nothing to do with Wayfarer. Shusty had nothing to do with Wayfarer. She's had to concede that already in her Rule 56.1 statement. So what other specific articles, because this is the thing with Lively, right? She hasn't actually pointed to any specific articles, right? And you can't just say, well, the Daily Mail printed a hit piece on me, right? It made me look bad, so therefore it's Wayfarer's fault. She's got to prove Wayfarer was behind that article being printed in the format that it was printed in, and said the things that it said because they requested it. It was somehow because of Wayfarer's actions. And in that opposition letter to Wayfarer's motion for the extension of time, we'll call it, Wayfarer obviously saying, look, she's dumped a load of exhibits, right? And one of them is a Taylor Swift cookie recipe. And Lively actually gave us a flavour of what kind of articles or, what kind of things is she pointing to that allegedly damaged her. And that cookie recipe is one of them, because Blake Lively fired back and said, no, it's relevant. Melissa Nathan sent it to the Daily Mail. So if she is trying to say that her reputation has been damaged by a Taylor Swift cookie recipe, right? Then, well, at that point, if your ego is that fragile, you're the problem. To be honest, you're the problem. But if that's the level of smear campaign, this case is going to be laughed out of court quick enough. But let's just say that point 1 and 2 are hit, right? So, they're ticked off. Yes, she's achieved that. Point 3. She then has to prove that, the smear campaign took place because she opposed this hostile work environment, because she complained about sexual harassment. And you know, and that it was a substantial motivating reason, like, that was the reason, substantial reason, not the sole reason necessarily, but the substantial reason that, Wayfarer decided to smear her. So if the jury looks at all the evidence of her trying to take over the movie and steal the movie, that can be part of it, but that can't be the substantial motivating factor. If it is, then they have to say, "No, we don't agree that, Blake Lively does not win." And, it can't be just a small it's gotta be substantial. So it can't be about, we're pissed off with her because she took over the movie. There's a little bit of us, like, let's just get back at her as well for, the fact that she made these complaints and allegations, blah, blah, blah. It can't just be a small amount, it's gotta be a substantial factor. And I think she's gonna struggle there because, again, it goes back to, well, she wasn't the only one allegedly who had problems with Justin Baldoni and Jamie Heath on the set. According to Lively, it was all these women: Colleen Hoover, Alex Sachs, Christy Hall, Jenny Slate, Isabella Ferrer. Was anyone else smeared? I mean, they're all professionals. Anyone else smeared? No? Why just Blake Lively then? What did Blake Lively do that no one else seemed to do, in addition to making complaints? She tried to steal a movie. So I can't see how they get to, the complaints, the adverse, the protected activity was the motivating factor. I can't see how the jury would get there. They obviously could, they might, but at the end of the day, there's a powerful amount of evidence where Blake Lively pretty much took control of everything, including the HR, by the way, that she complains was lacking. She was the HR. And I think when you look at dissect the 17-point list, that is more of a tick box, like a, right, in order to become a producer, this is everything I need. And she's basically giving Wayfarer a shopping list of all the things she needs to, strong arm her way into becoming a producer. And I think at the end of the day, you can't say that a bunch of people have been smeared. A bunch of people have complained about hostile work environment, or et cetera, et cetera. Because technically, then they've all engaged in protected activity. Then by Blake Lively's kind of, by the standard that we're applying to Blake Lively, if Jenny certainly did, because she raised her concerns. She had an apology. Why was she not smeared? And when what's left is, well, one tried to take over the movie and the other didn't. So then you look at, well, the more likely the scenario is the grounds for the actual smear campaign, if there even was one, which I don't believe for a second there was, is surely it's more likely to be because she was trying to steal the movie. But again, I don't think there was. Then we get to right. So we'll assume for the purposes of this that the first three elements have been ticked off. Miss Lively was harmed, right? Miss Lively was continuing to do film. She was invited onto Saturday Night SNL, the 50th anniversary, to host that. She was filming in Capri for Another Simple Favor and promoting that. She won awards. Her Blake Brown beauty stuff crap won awards. She won the Times 100 most influential woman. Has she been harmed? Who knows? I mean, that's for her to prove. She has to prove that. But if you're winning awards and you're still working and getting invited to gigs, you're going to struggle to prove that you have been harmed and you've lost jobs and lost profits. Because I mean, we looked at some of the Blake Brown, the Family Hive. When we looked at the agreements and all that, what she's claiming to be lost profits was actually it was a debt. a loan that had been taken out the year before. So it's not quite as cut and shut as that. But she also has to prove as well. Like, let's just take Blake Brown Beauty, right? I saw a lot of influencers, like hairdressing influencers, who, when they try a product and they review it on their YouTube channel, and a lot of them said, "No, it's awful." Well, they're gonna have some influence, and they're not retaliating. They're not part of Wayfarer's, they're not on Wayfarer's payroll. She'll try to spin it like that, but that's their job, is to review products, and they don't discriminate. They haven't just done it for her products. They've done That's their job, is to review, products from all kinds of brands and give honest reviews. And if they've said, "Oh, do you know what? This is awful," that will have a lot of influence and might affect her sales. But then her sales are being affected because the product is awful, not because she engaged in protected activity. Um Again, let's assume that she's checked off all the first four. She was harmed. It was because she engaged in a protected activity, and Wayfarer Studios subjected her to an adverse action, and that was a substantial motivating reason. Then we got point 5. Wayfarer Studios, it ends with this movie's conduct was a substantial factor in causing Miss Lively's harm. Again, like, if a professional hairdresser is reviewing Blake Brown Beauty products, her hair care range, on their YouTube platform, which they've done for, many brands before her, and they've gone, "Oh, I don't like that," and then the sales dip, and then Target start practically giving them away. That is not, Wayfarer then are not a substantial factor in causing that harm. Same with her own statements. If you're pissing off domestic violence survivors, past, present, and future, with your rhetoric and your scoffing and snarling and basically looking down at people who have been through that, when you are fortunate enough by your own admission to have never gone through anything like that, and you're promoting alcohol, knowing that there is a causal link between alcohol and domestic violence, then you've got no one else to blame for your misfortune than yourself. And Wayfarer will cite that, and I would be really surprised if the jury, anyone on the jury, would listen to that testimony and go, "Yeah, there's no link here. It was definitely all Wayfarer's fault." Blake Lively acted completely honorably, and did not cause any of her own downfall. So we have all of that to get through. And I don't think, even if she gets through some of it, I don't think she does get through all of it. But she needs to get through all of it. She needs to hit all of those points. Otherwise, she cannot win. Now, she then goes on to say Miss Lively does not have to prove harassment in order to be protected from retaliation. She's right. That's true. She doesn't need to prove that she was harassed. What she needs to do is prove that she reasonably believed that she had been subjected to harassing behavior, or conduct that was unlawful. So that is a fair point. If she reasonably believes that Wayfarer Studios at Entrance Movies conduct was unlawful, right? I don't like the way she's phrased that. It's not. No, it's not. The conduct was unlawful is diluting it a bit, right? She is alleged sexual harassment in the workplace. And then she has complained of said sexual harassment in the workplace. When we say conduct was unlawful, that's very broad. That's going way beyond what she actually complained about. She may prevail on a retaliation claim even if she does not present or prevail on a separate claim for harassment. Well, you're not going to present or prevail on a separate claim for harassment because they got thrown out. Okay, so let's see what Wayfarer they proposed their own set of instructions. Let's see. Um, by the way, the 5 elements that Lively listed here are what should have been in the checkbox for the verdict form, right? Like, was it this? Was it this? And did it occur because of this? And all the elements. And that's what pissed me off with the verdict form was like, she was like, did Wayfarer, retaliate against me? Okay, yeah, if you've said yes, how much money are you going to give me? That was literally her verdict form, which is not enough because the jury need to know, they need to question whether all of these elements have been, reached. Okay, Wayfarer's proposed instruction. Ms. Lively claims that Wayfarer Studios and Enter This Movie retaliated against her for engaging in protected activity, namely complaining about or opposing alleged sexual harassment. Yeah. Can I just check that a minute? Yeah. She she's put alleged harassment based on sex or gender. They've said alleged sexual harassment. So it's so far it's the same. To establish this claim, Miss Lively must prove each and all of the following. Right. So far they're on the same page. 1, that Miss Lively complained about or opposed the alleged sexual harassment based on a reasonable belief that she had experienced sexual harassment. The Wayfarer are keeping in the phrase sexual harassment to make sure that the jury are, following the correct definitions. Lively is being a bit looser, shall we say, in the hope that if she casts her net wider, she might catch some fish. Right. 2, Wayfarer Studios and or, right? They put and or in. It ends with this movie subjected her to an adverse employment action. 3, that Miss Lively's complaints or opposition to the alleged sexual harassment was a substantial motivating reason for Wayfarer Studios and Endless Movies conduct. 4, that Miss Lively was harmed. 5, that Wayfarer Studios It Ends With Us Movies conduct was a substantial factor in causing Miss Lively's harm. Miss Lively does not need to prove harassment in order to be protected from retaliation. If she reasonably believed that Wayfarer Studios' Ends With Us Movies conduct was unlawful, she may prevail on a retaliation claim even if she does not present or prevail on a separate claim for harassment. So, Lively's position on this. Plaintiff maintains that the instruction must include her allegation that Wayfarer Movies' It Ends With Us movie retaliated against Miss Lively not only because she engaged in protected activity, but also because she anticipated that she would continue to do so, which is absolute bullshit. How can you? They may have anticipated it, but if it hasn't happened, how can you claim for it? What a stupid position. Also, because she anticipated that she would continue to do so, including by filing a lawsuit, as illustrated by defendant's own contemporaneous text. Defendant's position misstates California law, which prohibits employers from retaliating against those who are believed to be prospective complainants or witnesses for complainants, and holds that a finding to the contrary would condone an absurd result. And then the defendant's position, Wayfarer's position. Anticipatory retaliation is not actionable. Thank you. Defendants have filed a motion in limine on the issue, so there is that as well. Moreover, the instruction must reflect the requirement that Miss Lively's actions were based on her reasonable belief regarding alleged sexual harassment. Yep. Really important because I find that Lively seems to be just broadening it, like, she's dropped the sexual, she's just harassment. Well, harassment encompasses sexual harassment, but other harassment too. And that was not what she ever complained about. And until her sexual harassment claims got thrown out, she always referred to it as sexual harassment. She didn't, water it down. Now it's being watered down to try and almost make it go further and, you know, confuse the jury a little bit into thinking that, you know, like some of these actions, that she's complaining of, while they might not meet the threshold for sexual harassment, but they could meet the threshold for, another form of harassment or, conduct, hostile work conduct. And she, again, slight hand with the words. But we're always seeing that with Lively, so it's not even a surprise anymore. Okay, they're going to define protected activity now. So Lively's proposed instruction. With respect to the first element, protected activity can take many forms. To establish protected activity, Miss Lively need not have expressly informed Wayfarer Studios at Evansville's movie that she believed their conduct was harassing or otherwise violated the PIHA. Miss Lively was not required to use legal terms or buzzwords when opposing harassment or to make a formal or written complaint. Instead, you may find protected activity if her comments and actions, when read in their totality, oppose harassment, and that such opposition was sufficiently conveyed to Wayfarer Studios. Miss Lively also need not prove sexual harassment to have engaged in protected activity, and you need not determine whether the relevant conduct rose to the level of sexual harassment. You may find that Miss Lively's belief was reasonable so long as it was not utterly baseless. Miss Lively alleges that she engaged in protected activity by 1. Complaining about the sexual harassment in May and June 2023. 2. Lodging complaints through the protections letter in November 2023. 3. During the Mia's whining, sorry, if you can hear her, I'm sorry. 3. During the January 4th, 2024 all hands meeting. 4. Declining to appear in promotion with Mr. Baldoni, Mr. Heath, or Wayfarer Studios between June and August 2024. And 5. Filing her CRD complaint in this lawsuit in December 2024. You may consider any protected activity in considering the substantial motivating reason element, which I will instruct you on separately. Okay, so Wayfarer got their own proposed instruction. In order to show that any of her actions in complaining or opposing the alleged harassment was protected activity, the plaintiff must prove that 1. The action in question was based on a good faith, reasonable belief that defendants discriminated against her based on her sex, and 2. The action in question was sufficient to convey to the defendants that the plaintiff believed discrimination was occurring and took the action in question with the intent to oppose it. Okay. And then they continue. That is, to be considered protected activity, the plaintiff must prove that the conduct was something she did to oppose what she reasonably believed was unlawful discrimination, and that the defendants would have understood the plaintiff's conduct to be opposing such discrimination. In addition, not all forms of protest are protected. The way in which a party presses complaints of discrimination can be so disruptive that it strips away protections against retaliation. A defendant does not engage in unlawful retaliation when it takes an adverse action against a party to preserve a workplace environment that is governed by rules, subject to a chain of command, free of commotion, and or conducive to the work of the enterprise. So Lively takes a position. Plaintiff's proposed instruction is appropriate and critical to instruct the jury with respect to what constitutes protected activity, and closely tracks case law regarding the same. Defendant's objection misstates one of the alleged protected activities at issue. Miss Lively does not assert that she engaged in a protected act by allegedly taking over the marketing and promotion of the film. Rather, she asserts that her decision not to appear publicly with Mr. Baldoni or Mr. Heath during press and promotion of the film constituted further opposition to their harassing and retaliatory conduct towards her. What, that happened a year before? Like, they finished the whole second phase absolutely fine. And, suddenly she, and that was in February as well. And then by August, more than a year after she had allegedly been harassed, after everything had been fine for months and months and months, she needed to take this opposing action. Right, I'm gonna cool my jets a bit because I'm hoping Wayfarer will absolutely decimate this argument because it's so stupid. Is that why she asked Colleen Hoover to unfollow Justin Baldoni to oppose their harassing and retaliatory conduct? They hadn't retaliated against her, by the way, during the marketing and the promotion. They had not actually retaliated anything at all, even by Lively's allegations. So how is refusing to appear in the marketing and promotion with Justin Baldoni opposing retaliation? That makes no fucking sense. Such opposition may constitute protected activity, including where, as here, defendants' contemporaneous communications indicate that they understood Miss Lively's conduct to convey opposition to their prior harassing acts. And then she cites some law. In addition, this is not a discrimination case. There is no discrimination cause of action alleged. No, because it was thrown out. And it is very confusing to continue to use the term discrimination when that is not at issue. Further, CACI 2505 calls for a description of the alleged protected activity at issue. Further, defendants' proposed instruction includes prejudicial, misleading, argumentative, and inaccurate statements in the final paragraph with respect to stripping away protections against retaliation. During conferrals, defendants' counsel was unable to articulate what activity by Miss Lively would warrant such instruction. The facts at issue here do not come close to those in defendants' cited cases. Perhaps even more importantly, defendants' cases apply in the context of employers undertaking adverse actions for the purpose of ceasing active disruptions caused by employees. Matima, for example, considered an employer's decision to suspend the protesting employee based on his repeatedly yelling at others in the workplace. Defendants have not identified a single allegedly disruptive act by Miss Lively, only vaguely referring to communications related to Miss Lively's creative contributions. That's how we're framing it, creative contributions to the film. They cannot reasonably argue that they were justified in attacking Miss Lively's character, among other adverse acts, in August 2024, simply because she provided creative input on the film. That is not and cannot be the law. Indeed, such holding would gut the meaningful and essential workplace protections that FIHA was designed to provide. Defendants provided their below stated position after 6, I'm guessing PM Eastern, on the date of filing. For that reason and the others stated above, should the court maintain this instruction, Ms. Lively requests a further briefing on the propriety thereof. The defendant's position. Plaintiff's proposed instruction is argumentative, prejudicial, and likely to confuse the jury. Preliminarily, her description of her purported conduct assumes the truth of the contested facts. That Lively complained about sexual harassment. Yeah, it does a bit. Her proposed instruction also fails to clearly delineate the essential elements of good faith and notice, both of which are clearly established in case law and present in standard instructions on this issue. Janowitz, on which Lively relies, also expressly references the good faith requirement. And Castro Ramirez discusses the notice issue at length, It holds complaints about personal grievances or vague or conclusory remarks that fail to put an employer on notice as to what conduct it should investigate will not suffice to establish protected conduct. Lively relies on a subsequent portion of that decision concerning legal terms and buzzwords, which is not on point. That issue typically comes up when an unsophisticated, unrepresented party makes a complaint without using appropriate legal terms. Lively, on the other hand, was a highly sophisticated party with legal counsel who, in fact, raised a concern through lawyers. A clear instruction on the element of good faith and notice is essential here, because Lively claims as protected activity actions that fall well outside what would generally be understood or recognized in that category, such as her refusal to market the film alongside its director. Whether such conduct was in fact intended in good faith to oppose discrimination or instead to further Lively's ulterior motives, and whether the Wayfarer parties should have reasonably understood it as an effort to oppose discrimination rather than as a power play, are two hotly disputed issues in the case. Defendants' proposed instructions appropriately orient the jury to these issues. For the same reasons, defendants' proposed instruction on the limits of protected activity as articulated by the Matima is appropriate. Lively does not dispute that defendants' proposed instruction accurately represents and indeed almost precisely tracks Matima, which states, not all forms of protest are protected by Title VII's prohibition on retaliation. An employer does not violate Title VII when it takes adverse employment action against an employee to preserve a workplace environment that is governed by rules, subject to a chain of command, free of commotion, and conducive to the work of the enterprise. Nor does Lively dispute that the same principle applies in the FEHA context. Instead, she apparently claims there is no evidentiary basis for the instruction based on her own view of the facts. The Wayfarer parties, of course, have a different view, as discussed at length in the summary judgment papers and elsewhere. The Wayfarer parties and others at Sony viewed Lively's conduct to be extraordinarily disruptive. Sony executives repeatedly referred to her as a terrorist. I mean, they did. Observed that Lively had orchestrated all this drama around the premiere and threatened the success of the film in the process. In other words, Lively is free to argue to the jury that her conduct was not disruptive. The Wayfarer parties are free to argue the opposite. The purpose of jury instructions is not to resolve such disputes, but to accurately state the law to the jury. Defendant's proposal does so, Lively's does not. Finally, defendant's use of the term discrimination is entirely appropriate. Lively has consistently claimed that she was raising concerns about sexual harassment, which is actionable specifically because it is a form of discrimination. Yes, exactly. That is a very good point. She was, the sexual harassment occurred on the basis of her sex or gender. That is discrimination. And one of the key things that Lyman said, especially in regards to the comment by, Isabella Ferrer that she took a exception to, I think it was something about, what they had just filmed looked hot or sexy. I can't remember which. I'm getting confused between those two words now. But basically, Judge Lyman himself said, well, hold on a minute. Baldoni also said it to the male actor as well as the female one. So it's not discrimination. It's not sexual harassment. Her complaint specifically asserts that she was retaliated against for raising concerns about unlawful conduct based on sex. Yeah. Adverse action explained, right? So there is a joint instruction. So they've agreed on this part. As to the second element, Miss Lively must prove that she was subjected to an adverse employment action. Adverse employment actions are not limited to ultimate actions, such as termination or demotion. There is an adverse employment action if Wayfarer Studios or Enzo's movie has taken action or engaged in a course or pattern of conduct that, taken as a whole, materially and adversely affected the terms, conditions, or privileges of Miss Lively's employment. I mean, there was nothing that adversely affected Lively's employment, let's be clear. An adverse employment action includes conduct that is reasonably likely to impair a reasonable employee's job performance or prospects for advancement or promotion. She got a promotion, a big one. However minor or trivial actions or conduct that is not reasonably likely to do more than anger or upset an employee cannot constitute an adverse employment action. So, Lively's proposed addition. Alleged adverse acts should be considered collectively rather than individually, and may take the form of a series of subtle yet damaging injuries. Here, Miss Lively alleges that Wayfarer Studios subjected her to adverse treatment, including by discouraging and obstructing her ability to complain about the hostile environment. You complained, and you could have gone to other places as well, like SAG-AFTRA. You didn't, but you did go to Sony. And she went to Alex Sachs, who was the producer. Discouraging and obstructing her ability to complain about the hostile environment. I mean, she utilized her own bloody lawyer as well. Like, the 17-point letter was, we'll do it this way and we'll forego a formal HR process. Attacking a character and professional reputation, including through a negative press and digital media campaign, threatening and or attempting to intimidate Miss Lively and third parties. What third parties? And filing a frivolous and factually baseless retaliatory lawsuit against her. An adverse act may include employer conduct that sullies an employee's reputation, such as providing a negative job reference or making negative public statements about an employee's character or professional reputation. So her position, that was an additional excerpt that Lively wanted to put in. Her position, that parties agree on the core language of this instruction. Plaintiff submits that the instruction should further include guidance with respect to the adverse acts at issue. In this case, including that adverse actions may include efforts to disparage an employee's character or reputation, including through negative references. Contrary to defendant's stated position, this instruction does not misstate the holding of Janowitz, which is clear that an adverse action includes the entire spectrum of employment actions that are reasonably likely to adversely and materially affect an employee's job performance or opportunity for advancement in his or her career. What advance? This would make sense in an office type job, where you spend your time, you do well at the job, and then you work your way up the chain. This is just she's on a film set for a limited amount of time. What advancement? And even if she is seeking some advancement, she got her PGA mark. Wayfarer's position. Plaintiff's instruction does not accurately state the holding in Janowitz, which affirms that FIHA, unlike Title VII, is limited to adverse employment actions, and that such actions must materially affect the terms and conditions of employment. The instruction should be limited to the CACI language. Okay, reasonable belief. There's no proposed instruction from Lively because she doesn't have one. Defendant's proposed instruction. Defendants have not been found liable for sexual harassment against Miss Lively. The question in this case is not whether sexual harassment occurred, but whether Miss Lively had a good faith, reasonable basis to complain about or oppose defendant's conduct. If you find that she had a good faith, reasonable basis, you need not consider whether defendant's conduct actually rose to the level of sexual harassment in considering her claims for retaliation. On the other hand, if you find that she did not have a reasonable good faith basis, you must find that defendants are not liable for retaliation. Okay. Plaintiff's position on this. Defendant's proposed instruction is argumentative and misleading. I don't think so. As well as duplicative of both the agreed to instruction under the CACI 2501, which specifically addresses reasonable belief, as well as the parties' separate proposed instructions as to protected activity. It is therefore unnecessary. Further, defendants grossly misstate the court's April 2nd summary judgment order. The court did not find that defendants are not liable for sexual harassment. Did they say that? Hold on. No, what Wayfarer actually said is that they have not been found liable. Not that they didn't say that the court found them not liable. They're saying that they have not been found liable. They've not misstated. Oh God, this woman. The court did not find that the defendants are not liable for harassment, nor that defendants did not engage in harassing conduct. Instead, the court merely held that California law did not apply to plaintiffs' harassment claims extraterritorially. Yeah, so why are we still pursuing FIHA retaliation then? And or plaintiff was an independent contractor rather than an employee. In addition, defendant's proposed instruction wrongly and improperly pre-bakes into the jury's mind an assumption that plaintiff was not only not sexually harassed, but that it has been affirmatively adjudicated on the merits that defendants did not harass her as a matter of law. This leads the jury to assume that plaintiff's belief was neither reasonable nor in good faith. It is highly inappropriate and prejudicial to instruct the jury as proposed. Further, defendants only provided this proposed instruction after 6 p.m. Eastern on the date of file. Oh, for that reason and the others stated above, the court should the court entertain this instruction, Ms. Lively requests further briefing on the propriety thereof. Wayfarer's position. The proposed instruction is a correct statement of law. Defendants have not been found liable for sexual harassment, nor is there any such claim remaining. That's fair. Plaintiff's exhibit and witness list indicate she intends to put on hours of evidence regarding her reasonable belief, and the jury must be instructed as to the relevance of the evidence and what claim they are deciding. Okay. Right, so we then go on to reasonable defensive measures. What I think I'm going to do though is because there's still quite a lot to go through, and we're already at the hour point nearly, so I'm going to stop here and I'm going to then continue, maybe make this a bit of a mini series. I think it's going to take a couple more hour-long videos. Yeah, I'm going to do that. All right, I'll stop here and then I'll continue with reasonable defensive measures in the next video.